Hello, everyone, and welcome to this week's episode of the Oxford Policy Pod. My name is Meredith Lehman, and I'm joined by my co-host, Thanu. And today we are kicking off a brand new series on the future of international law, a topic that has never felt more urgent or contested. We're absolutely delighted to welcome our first guest, Professor Philippa Webb KC. Philippa is a professor of public international law at Oxford's Blavatnik School of Government, the co-founder and director of the Institute for Technology and Justice, and a fellow at Exeter College, Oxford. And she's recently been described as the foremost expert on state immunity, and her research spans all of international law. So, Philippa, welcome to the pod.
Thank you so much. Delighted to be here. Thank you so much for being here, Philippa. And now we should say that most of our listeners are either students at Oxford or are past students at Oxford, so are very familiar with your work. And really, it's your course that inspired us to plan this series on international law. So thank you for all your insights throughout this term. But we did actually want to start maybe with what drew you into international law in the first place.
So growing up in Australia to parents who had moved to that country, so my mum's from the Philippines and my dad's from New Zealand, I always had a very international outlook. And as you know, Australians travel far and wide and work all around the world. And during my law degree, it was international law that really attracted me, first just for that outlook beyond one jurisdiction. But then as I studied it further, I was very attracted to how it put human dignity at the center of the development of the law. And that led to an even deeper interest that I pursued later at the United Nations, the International Court of Justice, the International Criminal Court, and then in my academic and practice life.
Fantastic.
Yeah. Well, I guess just transitioning a little bit into some sort of current topics.
Yes.
And yeah, a lot of what our episode is about today. So when we're looking at international law today, the strains on multilateral institutions, non-compliance by major powers, events like the war in Ukraine and escalation in Gaza,
Yes.
there's a temptation to reach for the word crisis. And do you think that's sort of the right frame to have on the state of international law today?
I don't. And I've written an article on why a crisis lens is largely unhelpful for this scenario. And it wasn't just my work. I was very much reflecting on the work of Hilary Charlesworth, who's now the Australian judge at the International Court of Justice, who in the 1990s wrote about international law as a discipline of crisis and why that held back and narrowed and skewed the perspective that people took on international law by viewing it through crisis. I think another problem with the crisis approach is that it makes us very short-term in our thinking. International law and the international legal order have faced multiple crises before and survived and sometimes come out stronger, or at least reformed and better adapted to the situation. So I think taking a longer-term view is important. I think another disadvantage of the crisis lens is that, and it was first Judge Charlesworth who said this, it allows leaders, whether they are the legal counsel advising or the political leaders, to cast themselves as the heroes of the moment. And I think we're certainly seeing that at this time, which is a counterproductive attitude to be taking to the peaceful settlement of international disputes, where it's not about ego or winning necessarily, but about achieving an outcome that enhances human dignity to the maximum extent. So what I've written about in the context of crisis is that we should take a different approach, and I call it an epoch approach, an epoch being a longer period of time. It's not a defined number. It's probably longer than a generation. And I say that we should have sort of three things in mind as we take an epoch approach to international law: the long-term view, lateral thinking, so questions around creativity in the law, and then linkages. And here at the Blavatnik School, we talk about unlikely coalitions a lot, and that's very much what the linkages aspect of an epoch approach advocates for.
I remember having Hilary Charlesworth as a lecturer actually while I was at Melbourne Law School. So it's really interesting for me as someone who learnt about the international system from someone like, yes, Judge Charlesworth, to now see it being challenged in a lot of ways.
Yes.
And I wonder, judges like Hilary Charlesworth or professionals like you, what is the influence you think you can have currently in shaping the discourse? I know you've written some fantastic articles on this. What is the process through which you can influence some of this thinking?
I think so when things broke out earlier this year with the Venezuelan, the U.S. Kidnapping of the Venezuelan head of state, I was immediately asked for my reaction from the media, from other podcasts, speaking at events, and my first reaction was to hesitate because it was quite shocking what had happened, and it was also quite unclear where it was going. But now as we come into March and it seems every day brings a new shocking development in international law, I have actually started to accept to speak about these things, whether it's behind closed doors, in roundtables with politicians and policymakers, whether it's in academic settings, whether it's in sort of mixed settings with the public invited or in a more policymaking context. Because even if we don't know exactly where this is going and what it means for the international legal order, I just think it's so important that we be clear about what is being challenged, what the law does have to say about it, because the law does have things to say about it, and to think about perhaps the unintended consequences or the precedents being set by these incidents. So what I've been doing is being more available for these conversations. And initially, as I said, my first reaction was at the beginning of the year. But it's also keeping an open mind to a very justified skepticism about international law that I am seeing, from the younger generation right through to very established people in their careers who are questioning its role and value in today's world. And I see my role as very much listening to that, acknowledging that as a valid and justified viewpoint, but also trying to put the alternative view that international law still matters.
A really important view.
So with that epoch framing in mind that you were sort of speaking about earlier, you've recently written an article which sort of sketches out 6 possible responses to these challenges we've been talking about, from defending international law as it stands all the way through to its fundamental sort of reconstruction.
Yes.
And so we're wondering if you can sort of walk us through that landscape a little bit.
Yes. So that came out of an invitation I had to speak at Chatham House to a really interesting group of, government and academics and civil society. And they asked me to sort of set the scene of how international law was being perceived at this time. And in thinking that through, I realized there wasn't one viewpoint. There probably has never been one viewpoint. And I thought, 3 or 5 would be a neat number. And in the end, I came up with 6 with my co-author, Lydia Kim. And we acknowledge right at the beginning of that piece that there's more viewpoints than the 6 we set out. There's certainly viewpoints from the global south that we probably haven't captured properly. So it is just a starting point and one perspective on the 6 viewpoints. But let me set out what they are. So they're along a spectrum, as you said, from sort of status quo to let's start over. So the first viewpoint is that international law should be maintained and respected even in the face of non-compliance. So that's sort of sticking to your guns and not adapting to the situations of challenge. The second viewpoint is that we should be trying to preserve the international legal order, but not at the expense of the national interest. And I think that is a viewpoint that's been expressed by a few people. I think it's quite a dangerous viewpoint because it's basically opting into international law when it suits you domestically and in your self-interest, and then opting out when it doesn't, which I think goes against the foundations of international law as something that's for the entire community globally. The third viewpoint is that we should be seeking innovation within the existing international legal order, and that's probably the viewpoint that I fit within, that I think there's a lot around international law that is imperceptible and that is working very well, and we shouldn't just throw everything out because of the high-profile violations. But at the same time, we can't be complacent that a system that was pretty much established post-World War II, there's obviously international law that goes back much further than that, but the current network of institutions and norms that we have is very much associated with that post-World War period. I think there's really valid arguments to be had that we need to reconsider that. The fourth viewpoint is that we should be trying to preserve just those parts of the international legal order that have the most buy-in. The challenge with that viewpoint is who decides which bits have the most buy-in and whose buy-in counts, because I don't think it counts equally from the people promoting this particular perspective. The fifth viewpoint is that we need a fundamental restructuring of the global world order, including international law. And there's different perspectives on that. One line of argument has been that we need to face the reality that the US is not the linchpin of the international legal order and probably hasn't been for a while. And we need to acknowledge that reality, incorporate it into our institutions, and become more open to different kinds of alliances and coalitions. And then the last viewpoint is a radical destruction and reconstruction and a brave new world, which is the most extreme in a way, but it's a good thought experiment, to test some views that we might just accept because they've always been that way.
Yeah.
Great. And I think within that, one of the approaches that you've suggested is incremental creativity, something that you can use within the existing system. Could you talk us through a little bit more about what that means and what that looks like for lawyers wanting to adopt that approach?
Yeah. So I'll give an example from state immunity and diplomatic immunity, which is an area that I've been sort of writing and researching in for over 20 years. There's been various attempts over the years to create a human rights exception to state immunity, which means that a state accused of a serious violation of international law, it could be genocide, it could be crimes against humanity, it could be torture, should not be immune for that conduct and therefore could be held accountable in a foreign domestic court. And there's been various attempts to create that exception, including in the European Court in the Al-Adsani case and the International Court of Justice in the jurisdictional immunities case between Germany and Italy, and then the Jones and Saudi Arabia case back in the European Court. And there's also been some domestic cases that have tried to make this argument, and they have generally failed because international law is largely created by states, and states have not generated a widespread and representative practice of being held accountable for their human rights violations. They have been happy to be taken to court, not happy, but they've accepted to be taken to court for their commercial transactions because that is what has enabled them to engage in those commercial transactions in the first place, because they've given that assurance that if something goes wrong, we will turn up to court. But they have not had the same attitude in general to human rights violations. So I noticed a lot of frustration with these attempts to create this exception, and then it's just being knocked back by court after court. And it's not just me, but some of us started talking about, well, what if we could use existing exceptions to advance human rights? So it's not going to work in every case because it obviously has to fit into the existing exception, but it could be a way to sort of move the needle on greater human rights protection rather than continuing to try to create an exception that's been rejected. And the concrete example is the case of Basfar and Wong, which you had in your seminars, which was a case decided by the UK Supreme Court. Now, it was a case by a domestic servant, Miss Wong, against a Saudi diplomat who she accused of treating her in conditions of modern slavery.
Mm.
And her allegations were very serious, that for 20 months she had been confined to this home, not allowed to leave. Her passport had been taken away. She had to wear a doorbell 24/7. She only got to eat the leftovers of the family. She was shouted at and harassed, and she had to sleep in a cupboard with the suitcases. Those were her allegations. Now that looks like a human rights case, but there's no human rights exception to diplomatic immunity, and we're not in a position really to create one. So we argued on behalf of Ms. Wong that this fell within the commercial activity exception to diplomatic immunity. So that is a very well-established exception in the Vienna Convention on Diplomatic Relations, Article 31, that says a diplomat is not immune for a commercial activity outside of his functions or her functions. So it had these two limbs, that it's a commercial activity and it's outside of their functions. And we argued that the allegations of how Ms. Wong was treated constituted a commercial activity, that there was a profit being made from her unpaid labor. Oh, the other thing is she had only been paid a pittance over that 20-month period, not at all what was provided for in the contract. Again, an allegation. It hadn't gone to the merits stage yet. And we were successful in the Supreme Court in establishing that as a precedent. So they did accept that such an apparently exploitative situation would fall under the commercial activity exception. So that's an example of incremental creativity, and that we didn't argue for a wholesale freestanding human rights exception, even though I personally see no reason why diplomats should not have to account for serious allegations of human rights. But that's not what states have agreed. It took a framework, which was her vast underpayment and the very exploitative employment conditions she was in, which are sort of both at the edge of human rights and commerciality, and fit it within an existing exception. So a lot of what I think about in my research and my practice is other areas where we could sort of move the needle in this way.
I mean, this approach is just really intriguing to me. One of the reasons is sort of that there's something almost paradoxical about it, being creative within constraints.
Yeah.
And do you think these constraints themselves are sort of enabling this creativity, that having these rules and institutions, despite being imperfect and having areas for improvement, sort of gives you something to work with?
I think it does. And that's why when I teach law and public policy, I say law is both a tool that can advance your policy and it's a constraint on that policy. But in constraining it, it's providing you with a path for how you can be successful, because you're not in a fluid environment where no one's listening to you. If you are working within the legal constraints, then you're going to have institutions like courts that have jurisdiction. You're going to have statutes that have codified the rules in the area, and you know what category you're trying to fit within. You're going to have a process like the adversarial process in a courtroom, but it can be other processes like legislation or executive procedures. And that is all kind of provided for you when you work within the constraints. You're not starting in this vast blue ocean. And even though your outcome may not be as radical as you hoped it would be, at least the infrastructure around it is already there to potentially support you.
It's so interesting. And I think you're not alone in calling for this sort of mix of realism and progressivism, and in a way in this case. And I think Lord Chancellor David Lammy and Lord Hermer have used this concept of progressive realism, and we've seen figures like Mark Carney also call for this similar sort of dual approach to approaching these challenges that we're facing. Do you see a link between those concepts and what you're suggesting? And if so, how can those two things interact on the world stage? Yeah.
I see overlaps. So when I talk about incremental creativity, I'm very much talking about in how law can help us realize human rights to a greater extent. Whereas I think the Lord Hermer and the Lord Chancellor David Lammy and Mark Carney obviously have a much broader picture involved in their discussions. But I think what's in common is that we're thinking about how do we work within current systems? How do we be realistic, as Mark Carney said, that that we're taking the sign out of the window because we're no longer being performative about what certain postures can achieve, but we're not completely departing from that. And what in particular Prime Minister Carney has been doing is bolstering the values-based alliances that still exist, building some new ones, using instruments, once again, the well-established instruments like trade agreements to start building alliances that may later be important for peace and security. So I think that there is some overlap in that we're trying to work within the existing system while not being complacent about its drawbacks.
And it seems, and correct me if I'm wrong here, but that some of this, the success of an incrementalist approach might rely on, having that framework to work within in the first place, and
Yes.
so a stronger rule of law. And if that's sort of deteriorating, what implications might that have for that sort of approach? And do you think it is deteriorating? Is it do those constraints still exist in the same way they did maybe several years ago? Or
Yes. So there's sort of two things here, and you said it very well. The concept of the rule of law and then how it's actually being realized in practice. I think our concept of the rule of law is still very strong. And of course, that varies from country to country, and we've seen research on that. But it's the essence of it, which is that no one is above the law, that you must have accountability and transparency. You must know things in advance if you're going to be held accountable for them, that human rights matter. All of those things, I think, are still very firmly part of the concept. The challenge is when those principles are not respected and no one says anything. And that is where we're seeing democratic backsliding. And I think we are seeing a deterioration in the rule of law. You've seen the research by the VDEM Institute saying more people are living in autocracies than democracies for the first time in over 2 decades. So it's very hard to imagine a fulfilling concept of the rule of law in an autocracy. So I think that there are the challenges. At the same time, even in these very inhospitable conditions, I think there's still opportunities to improve the lives of the citizens. And I'll just take an example. One of our alumna here at the Blavatsky School is Sarah Wahidi, who runs an NGO called Civam, and she also works with my institute as a technology specialist. And she's been using technology and the law to try to improve the lives, in particular, of women and girls in Afghanistan. And that's an environment where the rule of law is almost completely collapsed. But she's still been able to make inroads and improvements and given some hope to people, even in that most inhospitable environment. So whenever I'm sort of looking at the UK or the US or these democracies where we're seeing challenges, I always think, well, if Sarah can do it in that situation, then there must be a way for us to improve things in a much more welcoming environment from a legal perspective.
That's so interesting. Yeah, absolutely. And I think really fits into my next question, actually. And that's about the role of courts. Sort of in this article mentioned that all 6 positions may rely on the institutions that the international courts are.
Yeah.
Could you speak a little bit more about that and how we can ensure that these courts are fit for purpose going forward?
So there's sort of 2 levels. There's the international courts and there's the domestic courts. And international law appears in both because international law is part of every domestic legal system in different ways. It might be transformed and incorporated, or it might be just received in a monis system. But international law is appearing in these 2 levels of courts, and research has shown actually 50% of the activity around international law is happening in the domestic courts. But of course, we have the very prominent courts like the International Court of Justice, the principal judicial organ of the UN. And what's interesting about the challenges to the international legal order and the range of these viewpoints is that the International Court of Justice remains pretty important in all of them. Right, maybe not the radical destruction, but right up until viewpoint 5, the International Court of Justice is playing a role. And while we've seen the UN Security Council be essentially rendered irrelevant by the veto power, at the same time, it's almost like states have taken their concerns about really existential issues or grave violations of human rights and brought them to the International Court of Justice. So the court is busier than ever and has a completely diverse range of parties appearing before it. It's from all regions of the world. It's not just one category using it. And it's both, quite focused, contentious cases about territorial disputes, which are, of course, of huge importance to the states involved, but then really broad cases, advisory opinions like the climate change advisory opinion, which seem to incorporate so many different areas of international law. So I think almost as much as we become disillusioned with certain bodies like the Security Council, it's almost energized the International Court of Justice at the same time. And when we think about the different viewpoints that I set out, in some, people are saying we should use the International Court of Justice more, or they say we should, make it mandatory because at the moment it's consent-based, or they say, there should be even greater Global South representation before the court. And I think all of these are legitimate things to think about, but what they seem to accept is the importance of this court. And if we just take climate change, for example, that is a question that had been dealt with in pretty much policy-only circles for a long time. And then maybe a decade ago, we started to have some litigation, including in domestic courts, like in the Dutch courts. There's been some really impactful litigation in the Agenda case. And now we've had advisory opinions from the International Tribunal for the Law of the Sea about the ocean in the climate system, from the Inter-American Court of Human Rights about the climate emergency and the right to a healthy environment, from the International Court of Justice on state responsibility and the different levels of responsibility for states and potential loss and damage claims. And pending before the African Court, a question as well in an advisory setting about what does it mean for the African Charter, which is not just human rights, but also people's rights, a collective approach to human rights, and how does that interact with climate change? So in a very short period of time for international law, we've had a really rich contribution of international courts to moving things forward. And now those cases are being invoked in domestic courts that may lead to accountability of particular entities and individuals.
When it comes to the courts, there's sort of this ongoing question that isn't really new, but the question of selective compliance. States turning to courts when it suits them and ignoring rulings that don't. And do you think that pattern ultimately undermines this project, or can courts still have an impact even when this enforcement is weaker?
Yeah. So the Achilles heel of the international legal system is that we don't have a police force or an army. Like, there's no real enforcement mechanism. For the International Court of Justice, the ultimate enforcement mechanism is to go to the Security Council, which means, and it's only happened once really, and it was vetoed, that the minute you have a P5 either being accused of not complying or an ally of a P5 member, you're going to get the threat of the veto, if not the veto. And yet, studies of compliance of ICJ judgments have found that there's compliance in the vast majority of cases, and it compares well with domestic systems where you have all of your procedures for actually ensuring people and entities comply with the law. So it's and that picture may change, although at the same time, states are turning to the courts and trusting them with their disputes more than ever. So actually, there's quite a good picture of compliance that shows that this is a multifactorial analysis. It's not just whether you have a penalty procedure in law that's enforceable, but it's also about trust and legitimacy and the fact that this is universal and open to every member state, the fact that over 80 years, the court has built up a corpus of jurisprudence that is largely respected and has largely been complied with. So I can see the risk in theory. I think in practice, for now, it's not playing out in that way. But just to the second part of your question, I think even if there is non-compliance by a specific state, which of course happens, I think there's still the authoritative interpretations of these courts of international law that has ramifications even if that specific decision isn't enforced.
So you're saying some of these non-compliance things that I don't know, might be getting more attention or more outliers than the rule?
Exactly. And it's also a temporal issue. It may be that immediately the losing party says, this is outrageous, we reject it. And then you'll find 5 years later they have quietly complied with it. So, yeah, the longer term view. Oh,
That quiet compliance, like where would that incentive
because there's
come from if they
there's
don't really-
other incentives for compliance. They may feel that their stance of rejecting that judgment or that position of the court has made them less credible when they're trying to criticize other states for non-compliance in other areas, or that they may be criticized in diplomatic fora and so on. Or they may just find that the time has come that they actually want to bring someone to court. So there's an incentive to finally comply. But there's also just time changes, and what seemed so outrageous in the moment actually later seems like a fairly stable compromise.
I think that's a really interesting and important viewpoint to draw out, because I think there's this underlying, maybe even PR problem international law has, right?
Definitely has a PR problem.
Yeah, everyone says it doesn't work, and therefore it kind of enables actors to continue to challenge, not to challenge, to kind of espouse that narrative, right? So it's important, I think, to challenge that. And I think your work at the Institute goes to sort of challenging some of those assumptions that we have and how tech and justice can contribute together to further human rights and other things across the globe. Could you talk us through what the Institute is doing at the moment and what drew you to found that institution?
Yes. So this is the Oxford Institute of Technology and Justice, which launched in October 2025. So the motivation behind it is that I had co-authored a couple of books with Amal Clooney, who's the head of the Clooney Foundation for Justice, and she's also a visiting professor here at the Blavatnik School. And in writing, we were writing these books on really fundamental rights. So a book on fair trial, which was 1,000 pages, and then a shorter book with a number of contributors on freedom of speech. And as we were working on these books, we kept thinking, but how is AI going to change this? Like, we're writing about fair trials, where you're not assuming that a pleading has been drafted by a chatbot, or where you're fully assured that the judge is not checking something on, an app. And those days have changed. AI has entered the courtroom, whether it's authorized or not. And it's increasingly authorized to enter the courtroom, as long as there's disclosure and there's guardrails on that. So we didn't get to deal with this in our book, and also in freedom of speech. We realized that we could be telling governments what their obligations are, but then what about the big tech platforms where so much speech takes place now? How does international law matter to them? So out of a very academic exercise that was literally about, reading thousands of judgments and decisions and distilling them and doing all the footnotes and having a hard copy of 1,000 pages, we sort of went to the other extreme and said, what if, these rights could be realized in a positive way with the assistance of technology, including artificial intelligence? And that's what we're doing at the Institute. So our mission is to harness AI to advance justice. And we are building AI-driven digital agents that are helping expand access to justice and the fair provision of justice in a number of ways. So just let me give you a couple of examples. So we're building a women's legal assistant that will provide women and girls with legal information on their rights, vetted legal information, and connect them with human lawyers who can assist them in situations of gender-based violence, child marriage, or financial abuse. And we're starting that off in Malawi because that is a country with 22 million people and 800 lawyers. And not all of those lawyers are working on women's rights. And we have an amazing partner in the Women's Lawyers Association of Malawi who we're co-creating these tools with. So in a spread out, vast country like Malawi, also with challenges in terms of tech penetration and the type of tech, it's not possible for people to see a lawyer. Like, there's a huge justice gap. But what if they could, at least in the first place, look on an app, even an app that works on low-tech devices to help them with that. So we're working on that. We're also at the other end of that relationship, helping the lawyers do their jobs more effectively through form-filling tools that will automate many of the steps, but not all of the steps for protection orders or divorce decrees, bail applications. And then on the freedom of speech side, we're working with the Committee to Protect Journalists to have a digital agent for journalists to access a lawyer trained in the jurisdiction and the law that's relevant, that's going to represent them for free or for a low rate. Because there's a lot of lawyers and legal professionals who are willing to do this, but in the moment, that first 48 hours after you're detained as a journalist just for doing your job, you're not necessarily going to have them at your fingertips. And we're hoping that tool will help close that gap as well. And then for the judges, who are often dealing with huge backlogs of cases, in India, it will take 300 years to clear the current backlog of cases. And even in the UK, there's a backlog of, I think, 80,000 cases in the Crown Court. So we're working on a tool called the Fair Trial Advisor that would give judges at their fingertips cited authoritative advice, not legal advice, but just a suggestion of how they can decide fair trial issues that arise during a proceeding. So they're not flicking through 1,000 pages of commentary, but they're just able to put in a quick prompt and get an answer that points them to the cases if they want to dig deeper into it. So these are exciting sort of initiatives we have underway. We're also launching with UNESCO a online course for 100,000 judges in 160 countries on how to use AI responsibly. So it feels like a very exciting time. And when we speak to people in this space, we ask them, could we be doing anything different or anything extra to have a positive impact on justice? And they say no. And then we ask, is anyone else doing it in this way? And they say no. And this is both a heavy responsibility because we feel like we're filling a vast space, but we're only a tiny entity. But it also motivates us because we realize that while there's been huge use of AI in engineering and medicine and climate and weather prediction, all of these things, justice has been left behind. So we're hoping to make a difference there.
That's great. It seems sort of like, I mean, a lot of the ongoing projects right now at the Institute for Technology and Justice, like have a strong focus in global South countries as well. And I think there's like a lot of really great use cases that you've mentioned for AI in the justice space. There's also this sort of tension that can exist with the rapid expansion of data centers, for example, and extreme sort of water use requirements to run and use technology like this. And so I'm curious to hear your thoughts on that sort of tension, balancing the useful ways that humanity can apply these technologies, but also being acutely aware of their limits and perhaps how we should limit ourselves in their usage.
Yeah. And that is why the principle of co-creation is really at the center of everything we do, because we don't want to be developing things that are wasteful of resources, that are going to become defunct within a year, that people won't use even though they look very nice. We want them to be useful. So it's been interesting actually working with the Women Lawyers Association of Malawi, because they were the ones that said to us, what we really need help with is this protective order form. It's really complicated. It takes us days of interviews to get the information. And now you can have a digital agent that asks questions in natural language processing that solicits a lot of the information that they need in order to facilitate these forms. And that's something that we couldn't have known from the outside. And it's very much a need that they have. And that we hope we're working with them to meet. On the environmental impact, I think that's a huge issue. But I wonder, and certainly I asked this question of James Manyika, who's a visiting professor here at the school as well, and a vice president of Google. And he made the really interesting point that because big companies are now realizing that they need these resources, they're also going to accelerate their research and support for renewable resources. And I think, the only silver lining perhaps of the current war raging in the Middle East is that it's made us realize how important it is to invest in green energy and renewable energy. So it's something constantly to be balanced and kept in mind, but there could be a positive reinforcement that, okay, if we need more resources to run these centers, then we better find a clean way to produce that.
Yeah. It's interesting. Yeah, and not at the sort of needing to adapt to that before, because we also know that a lot of these countries will have to face the consequences disproportionately to things like climate change and like resource extraction. And so I think that is a really important point you bring up. It's also interesting that it seems like something that you would think is intuitive, but just is not actually implemented that often. The idea of co-creation and actually in involving the people who your program affects in its development, which is just it's really great to see and surprisingly rare, I think.
I know, and we're actually hoping to develop training on it within the Blavatnik School, because we just think it's completely central to this kind of activity, and not just in justice. I think any kind of AI application where you're working with communities, this is how to make it effective and more sustainable.
Absolutely. And Philippa, you've written a lot actually about integrating awe and hope in your work. And I actually found it quite moving at the end of one of your articles, how you spoke about that can not only keep us personally driven, but as a world hopeful about what can come. And I think I've been thinking a lot about it, especially because I'm realizing that it's actually quite a big incentive for those who are undermining international law, those who are undermining the rules and norms, for us to lose that hope. So how do you go about maintaining that hope, given everything that is happening, and how can everyone else listening do the same?
Just back to your point you made earlier, which is that international law has a PR problem. This is my writing about hope and awe came out of my reading of research on hope-based communication. Because research shows that when you present a problem just as a problem, like a dire, awful problem, you'll get attention, you'll get the clicks, but people will feel quite deflated by it and probably avoid it afterwards, and certainly not act on it. Whereas if you present the problem, but then you present the hope, the potential solutions, that's what gets people to act and support. And that's what the UN needs, among others. But in my own life, I think there's always moments of hope. You just have to sort of train yourself to look for them, even in the most depressing situations. You look at the first responders, right? There's these selfless acts of human being to human being. You look at young activists, and I look to your generation as well. I'm so impressed with how well informed you are, how digitally native you are, but also how open-minded you are towards each other. So that gives me a lot of hope. I don't want to be one of these people saying it's all on your shoulders. We'll do as much as we can as well. But at least we know the next generation coming up has a lot of skills and talent to deploy here as well. And then awe, which is the other emotion that I spoke about in my writing, is a really important emotion because it makes you realize that you're just a tiny part of a big universe, but not to feel minimized by that, to feel the interconnectivity and the sort of humbling nature of that in a positive way. And I have to say, as the sun is coming out in Oxford, as I see the magnolias and the cherry blossoms, I'm getting my awe and hope from those aspects as well.
Yeah, absolutely makes a difference.
It's crazy. The sun does crazy things. The first day it came out, I was like, wow.
Exaggerate.
person.
Yes, bottle that feeling.
And I guess sort of for your students and perhaps young practitioners who are entering international law today, and who maybe are nervous about what the future landscape might be, what would your advice be to them about how to think about this moment?
Yeah. So going right back to what we were sort of discussing at the beginning, I think take a long-term view, read some history. There's one thing to read the headlines that are bombarding us at every moment, and it's important to sit with that and to realize what's happening, but take the longer term view and see how we have succeeded in the past and some lessons for us for the present now. And I think, another thing we do at the Blavatnik School is welcome difficult conversations. And current events in the world give rise to a lot of difficult conversations. And we could just avoid them, talk about something else, or we can try and connect across them. And I think that's something that I've seen, your cohort doing really well. So, whether it's international law or policy or domestic politics, I think that skill of feeling uncomfortable but knowing that you're learning is a really important one to embrace.
Such a great note to end on. Thank you so much, Professor Philippa Webb. This has been such a great conversation and really illuminating in the current context. So thank you very much for taking time.
Thank you.